Dispute Resolution, PowerPoint 05, Module 1 of 2 modules. I expect you to understand this slide, but let me explain it first. What you're looking at here is how a constitution forms a government. And then we're going to look a little more carefully at how that government is formed by the Constitution. We start with the Constitution at number 1. At number 2, we see how the Constitution has divided the government up into 3 branches plus the administrative agencies. The branches of the government are the executive branch, the legislative branch, the judicial branch, and then there are many agencies created in the government. We are going to look more carefully at the judicial branch of government. In high school, you probably looked a little bit more at the legislative branch of government. That is, the House and the Senate, and how a bill becomes a law. In this class, we are going to look a little more carefully at the judicial branch of government and how the judicial branch of government makes laws. It is very, very different than how the legislative branch makes laws. Look at number 4 in the slide. This is how a typical judicial branch of a government in the Federation, called the United States, is organized. That is, there is a Supreme Court at the top, then there is a level of appeal courts, and then under the appeal courts we have the trial courts. All cases start in trial courts. All cases can be appealed to the appeal court. The Supreme Court, however, decides which cases it will take, and not all cases can be appealed to a Supreme Court. Next, look at number 5. The print there is a little small, so we're going to go to the next slide. This will give you an idea of the process that occurs in a typical trial court. It is still simplified, but it is enough for the average business person to know and understand. Start in the upper left-hand corner. In order to start a lawsuit, some facts have probably occurred that encourage the plaintiff to file a lawsuit. Sometimes plaintiffs just file lawsuits to be a pain, but we're going to assume that some facts have occurred that lead the plaintiff to file a lawsuit. Moving on to the next box, the plaintiff files a document called a complaint. This document starts the litigation process, and it briefly outlines the plaintiff's claims. The defendant then files a document called an answer. I do want to note that sometimes different court systems have different names for these documents, but they're all basically similar. At this point in our simplified process, we have a complaint and an answer filed. Together, these are called the pleadings. In a real case, the pleadings are much more complicated and would consist of cross-claims, counterclaims, etc. We won't get into that. Basically, the pleadings are all of the documents which outline in a very brief manner to the court why each of the parties thinks they should win. After the pleadings are filed comes the discovery process. This is actually the most important, most time-consuming, and most expensive aspect of litigation. This is the time when the parties attempt to discover all of the facts and all of the evidence that the other sides have and plan to introduce at trial. After the discovery process comes the trial. At the end of the trial, the judge signs a judgment which outlines who wins and how much money, if any, they win. If the losing party wants, the losing party may appeal. Everyone is always granted the right to appeal at least once to the appeal court. This way, the trial court judge's decisions are always subject to review by another panel of judges. Normally, at the appeal court level, The trial court and the trial is reviewed by a panel of 3 judges. Because only issues of law and value issues can be appealed, there is no jury at the appeal court level, and issues of fact are never reviewed. Look at number 2 in the diagram. At number 2, the appeal has been granted. Notice what happens. If the appeal is granted, then the matter goes back to the trial court. Notice there is a potential for a circular or many circular decisions. That is, the trial court could enter a judgment, it could be appealed, the appeal could be granted, it goes back to the trial court enters another judgment, a new appeal is filed and granted. If the appeal is granted, it comes back to the trial court, etc. It is not very common for this to happen. However, it is a possibility. For this simple diagram, I have assumed that the matter is not appealed to a state or the U.S. Supreme Court, and therefore, if the appeal is denied, notice that we go to the enforcement of judgment stage. That is number 3 in the diagram. The parties also get to the enforcement of judgment stage if they do not appeal. That is, after the trial and the judgment, if neither party appeals, the matter goes to the enforcement of judgment stage. The enforcement of judgment stage can also be a very long, expensive, and drawn-out process. If the losing party does not willingly pay the winning party, then the party who won has to enforce the judgment. If you win at a trial, all you get is a piece of paper that says you win. You do not get any money or any other relief. We won't look at the enforcement of judgment stage in any detail, but essentially the winning party must find assets belonging to the losing party, inform the sheriff or whatever office is charged with enforcing judgment of where these assets are, and then that office, or usually the sheriff, goes out, seizes the assets, and can sell them and then give them to the winning party. Of course, if the losing party has no money, the winning party is out of luck and will never receive any money on their judgment. Let's take a look at some of the documents mentioned in the previous slide. Here is a sample complaint. Here is what an answer to a complaint might look like. Here is a sample judgment. If you are interested in what the discovery process looks like, you can Google things like sample interrogatories or sample request for documents or sample deposition transcripts. Copies of some of these documents are also in the Readings and Exercises in Business Law text with PowerPoint number 5. Let me take a moment to explain the difference between facts and evidence. Remember, facts are a description of something that happened. In order to prove facts, we need some evidence. For example, look at this picture. The fact we want to prove is Fluffy ate the lipstick. What evidence do we have that Fluffy did eat the lipstick? And the answer is we have this photo with lipstick all over Fluffy's mouth and feet. That's pretty good evidence that Fluffy ate the lipstick. Pause and answer some questions. The term remedies or remedy refers to what the court can give the winning party in the judgment. Notice that in this judgment, the court has given the winning party money. The most common remedy is compensatory damages, also called monetary damages, also called money damages. In this situation, the court orders one party to pay another party a certain sum of money. The next remedy is called specific performance, and it is a court order to perform a contract. Courts do not like to award this remedy, but it is available in certain limited situations, such as the sale of real estate. The final remedy is an injunction. An injunction is a court order to do or not to do something in a situation where no contract is involved. For example, removing a fence that someone has placed on your property. There is a historical reason why we have specific performance and injunction. Even though they're both very similar, they are used in different situations only because of the historical development of the English common law. You do not have to worry about it other than to remember that although the two types of remedies are very similar, specific performance only relates to a court order to perform a contract, and any other type of court order to do or not to do something is called an injunction. Pause and answer some questions. This is also the end of this module.